Who is Ricky Brown? You are Graves? You are Graves. And you are Thomas. Switch places for me so I don't. Okay. Gentlemen, all of you are charged with racing on the highway. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Thank you, Judge.
Please.
The nature of this case is a racing on a highway case, so I just want to let you know that these dim summaries will be separate for each defendant because they were stopped at different locations, if that makes sense. Okay. On April 17th, 2025, in Harris County, Texas, an officer was on routine patrol when he observed a Silverado pickup truck and a Cadillac motor vehicle accelerate at a high rate of speed side by side in an attempt to outdistance one another. The officer observed a third vehicle, a Dodge Charger, increasing speed while following the other two motor vehicles. The officer accelerated approximately to 108 miles per hour in an attempt to catch up with the three vehicles. The officer noted the posted speed limit on the roadway was 65 miles per hour. The officer notes that he was traveling at 101 miles per hour, maintaining view of the vehicles and recording the incident with his dash camera. The Cadillac and the Silverado truck exited the freeway, and the officer got right behind the pickup truck and paced it, traveling 85 miles per hour. A traffic stop was conducted on the Silverado, and the defendant admitted to the officer he was racing with the other individuals. While speaking with the defendant...
We're talking about Brown, right?
Yes, Your Honor. Okay. And while speaking with the defendant, the other two vehicles arrived on scene and admitted to the officer that they were racing along with the defendant. I guess that covers that.
Who came and admitted?
It says the other two defendants.
The other two came in.
Yes, Your Honor, that's what it states. I'd be happy to read the other.
This is where it gets real. Judge Fleischer isn't just warning defendants, he's putting them on notice. In Texas, it's surprisingly easy to seize vehicles involved in street racing, including your brand new Dodge or Camaro. What would you do if your car was taken after one reckless race night? Let us know in the comments.
If you want to find that there's sufficient probable cause to go forward with your cases, gentlemen, let me tell you now that the state of Texas and the wisdom of our legislature has made it extremely easy for district attorneys across the state of Texas to seize and take cars from those who are arrested for racing. I have had cases in here where they have seized and taken a car from someone who was caught multiple times participate in this type of behavior. Don't do it. Do you understand?
Yes, sir.
If I find that you do, the first thing I will do is I will put you in jail, and then I'm going to take your ability to drive away from you while this case is open. Living in a city as big as Houston without the ability to drive blows. Do you understand?
Yes, sir.
Each of you, none of you participate racing, street takeovers, donuts, reckless driving maniacally, or putting others' lives in danger. Do you understand? If I find that you're driving at 100 or something like that, it's just not going to go well for you guys. So do you mind filing conditions on each of, racing, reckless driving, takeovers, anything of this nature, please?
Yes, Your Honor.
And then also, let's go through each one to see if they have valid licenses.
Yes, Your Honor. For defendant Thomas, we do have an eligible license.
Okay. Also, each of you you're not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. You must have car insurance. If you don't have either, you are not allowed to drive.
For defendant Brown, we do have an eligible license as well.
Okay.
And then for defendant Graves, the license is eligible.
All right. Gentlemen, do you have the ability to hire a lawyer, Mr. Brown? Okay. Do you have the ability to hire a lawyer? Okay, we're going to give you time to go hire a lawyer. We're going to give you 30 days. When you come back, please have a lawyer. I'm going to have you each go to Victoria, sign a reset. Then we will have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go. We have enough death on our streets. Don't contribute to it. You understand?
Sure.
All right, come on, guys. All right, you are Jose Castillo.
Yes, sir. Oh.
Mr. Castillo, you're charged with failure to stop, give information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. The defendant was driving westbound on 9100 Willow Meadow at approximately 7 p.m. and crashed into a parked white Chevy Silverado. The defendant's right side mirror struck the left side mirror of the parked pickup truck. The complaining witness identified the defendant's vehicle with surveillance video and rode around the neighborhood until he located the vehicle. The complaining witness gave the address to the officers who went to the location. They met with the defendant, who stated he was aware he hit the truck, but was going to go back later.
Okay. Mr. Castillo, I'm going to find that there's sufficient probable cause to go forward with the case. You run his license, please.
Yes, Your Honor.
You are not allowed to drive unless you have a valid Texas driver license and liability insurance. If I find that something like this happens again, or if you pick up a new case or become a danger, I will revoke your bond and put you in jail. Do you understand, sir?
Yes, Your Honor. It's eligible, Your Honor.
Okay. Mr. Castillo, do you have the ability to hire a lawyer? Okay, we're going to give you time. I'm going to have you go to Victoria, sign and reset. We will have you take a seat in the jury box while I get your bond conditions. Once you sign it, then you'll be free to go. Please.
All right, Judge, page 5, Contreras, come on up.
Sir, you are charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. The defendant and the complaining witness were in an Uber on April 17th, 2025, when a fight broke out. The defendant jumped on top of the complaining witness. The complaining witness and the defendant were dropped off by the Uber driver at the complaining witness's house. Once at the property, the complaining witness attempted to go inside.
Visible injuries, a second assault in less than 2 months, and now an ankle monitor. This isn't just a slap on the wrist. It's a full-on crackdown. The judge has even banned him from nightclubs and bars. What do you think? Should repeat offenders get second chances? Or is this exactly the kind of hard line we need?
The defendant started a physical altercation where he struck the complaining witness with closed fists, causing pain and injury to the complaining witness. The complaining witness was able to get away from the defendant and lock the door with the defendant outside. The complaining witness has visible injury and bleeding of the face observed by officers who arrived on the scene.
Relation, and is there alcohol or dope involved?
Let me tell you.
Just pled to an assault a month and a half ago, and here we are again.
Your Honor, the nature of the relationship, it states as a roommate of 2 weeks, and they were at a club known as Fuegos on Washington Street. And Your Honor, according to the dim summary, the complainant stated the defendant got too drunk.
We are now going to handle whatever issues that are arising with you. If I find that you're another danger to the community, I will put you in jail. You're ordered not to consume alcohol or illegal drugs, and I'm going to put an ankle monitor on you so I know that you're not consuming. You are not allowed to go to bars, nightclubs, anything of this nature where alcohol is primarily sold. Do you understand? So I'd like to put a scram on him. Okay, yeah. Waive the fee. You're not to have contact with the complaining witness in this case. If I find that you do, I will put you in jail. No more PR bonds. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer? What do you do with yourself these days?
I'm taking care of him. Stepdad has taken away everything from us. So we're trying to figure that out. And that's why I moved in with Chris.
It's time for you to get a job. And I'm making that a condition of your bond. You're not doing anything and you have way too much time on your hands. So you're becoming self-destructive. This is now your second assault case within the last month and a half. No more. Do you understand?
Yes, sir.
Can you reach out to the MAC for him, please? And then you're not to be in possession of weapons as well. I'm going to have you go to Victoria, sign a reset, and then we will have you take your seat in the jury box. You're going to have to get with them for your bond conditions. Then we'll get you a lawyer soon. Good morning, Mr. Crenshaw. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 19th, 2025, in Harris County, Texas, officers were dispatched to a disturbance call. An officer met with the complaining witness who stated that the defendant has been staying with him off and on. The complaining witness advised that he came home and found garbage in the apartment, which the defendant denied having done. The complaining witness stated the defendant started recording him, accusing him of threatening the defendant. The defendant then put the phone in the complaining witness's face, and the complaining witness took the phone, at which point the defendant punched the complaining witness several times in the face, causing pain. The defendant then attempted to take an electric scooter, which eventually struck the complaining witness in the leg, causing pain. The officer observed the complaining witness to have multiple injuries on his face.
All right, Mr. Crenshaw, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have contact with the complaining witness in this case and not to be in possession of any weapons. You understand? I don't see that a MOA or a protective order has been issued. Do you? You see a tray protective order?
The stipulations of my bond. I know that.
On Crenshaw, okay. I'm now entering in what's called a matchless order for emergency protection. This is a court order that identifies Mr. Montgomery as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is a stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where he lives or where he works. Do you understand?
Yes,
If you violate this court order, the state can and probably will file a violation of a protective order. It's one of the worst cases you can pick up.
yes,
Do you understand? Do you have the ability to hire a lawyer, Mr. Crenshaw? Do you work?
yes, sir. I'm currently looking for a job.
Okay, it's time.
Yes, sir.
We're going to make sure that that happens. So 2 weeks, I'm going to bring you back and I want to see what you have done to get a job. If you've done nothing, it's not going to go well for you.
Yes, sir.
You understand? All right. I'm going to appoint your lawyer. I'm going to have you go to Victoria Center Reset. We will have you take a seat in the jury box. I'm going to get you bond conditions. Do not leave until you sign them.
Yes, sir.
You're not to have contact. You're not to be in possession of weapons. You understand?
Yes, sir.
Come on.
Like a
Oh, hold on. Come sign for your protective order.
All right, Judge, next is page 6. Easy.
Hey,
Come on up.
can you file the no contact of weapons, please, on that? Mr. Crenshaw? Okay. Good morning, Ms. Woodward. Good morning, sir. So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
Okay, Your Honor.
On April 17th, 2025, in Harris County, Texas, the law enforcement officer made contact with the complaining witness who stated that she had a green light and the defendant's vehicle struck her on the driver's side. The complaining witness was transported to the hospital. A wheel witness stated that he saw the defendant driving at approximately 90 miles per hour and run the red light and hit the complaining witness's vehicle. The wheel witness followed the defendant, and the defendant stopped a few hundred yards away from the scene. The wheel witness stated that he believed the defendant was attempting to flee, but only stopped due to mechanical issues with his vehicle. The law enforcement officer came into contact with the defendant and noticed slurred speech, an odor of alcoholic beverage, red, bloodshot eyes, disorientation, and inability to follow instructions. The defendant admitted to driving. Standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, and the defendant refused the walk and turn and one-leg stand. The defendant also refused to provide a specimen. A blood warrant was obtained and a blood draw was executed.
Jesse, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're using, I will revoke your bond and put you in jail. Do you understand? Can you look to see any prior DWIs and if he has a license, please?
No prior DWIs and no license is eligible, Your Honor.
Okay, as long as you have a valid Texas driver license and liability insurance, you may continue to drive. But like I said, don't consume alcohol, don't use illegal drugs. You will be randomly tested. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with her and she'll tell you if and when you have to come back. For now, we'll have you go to Victoria, sign a reset. You'll get the pre-trial for your bond conditions and then you're free to go.
Thank you, Your Honor.
Hey, I don't have the, bond conditions for the third driver, Thomas. Did you file conditions on Thomas as well?
I did, Your Honor.
You didn't? Okay. Maybe we just don't have it yet. The second offense, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, sir.
Thank you, Your Honor. On April 17th, 2025, in Harris County, Texas, an officer observed a motor vehicle traveling at a high rate of speed. He observed the vehicle brake hard to slow down. The officer then got behind the vehicle and observed it to have an expired registration as of January 2025. A traffic stop was conducted and the defendant was identified by his Texas ID card. The officer approached the motor vehicle and observed the defendant in the driver's seat and the defendant to have glossy eyes, slurred speech, and an odor of alcoholic beverage. The defendant admitted to the officer that he had 5 to 6 beers prior to driving. The defendant stated he has a leg injury on his right leg. Standard field sobriety tests were conducted, a 4 out of 6 on the HGN, a 4 out of 8 on the walk and turn, a 1 out of 4 on the one leg stand. The defendant stated that despite his leg injury, he does work out and have an active life. The defendant stated he was a 5 out of 10 level of intoxication on a scale from 1 to 10. The DIC was read and the breath test strip was refused. A blood warrant was issued and the blood draw was executed.
Okay. Mr. Martinez, can you run his license, please?
Yes, Your Honor.
I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now, as a condition of your bond, not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you.
Yes,
So
sir.
if I find that you're using, I will put you in jail. No more PR bonds. Do you
Yes, sir.
understand?
Yes, sir.
I'm now placing a restriction on your license. You are not allowed to drive any vehicle that doesn't have an ignition interlock on it. If you're caught driving a vehicle that doesn't have one, I will put you in jail.
Yes, sir.
We are sending notice to DPS so that every single officer in this state knows that you're required to have an interlock in your car. So if you're caught wherever and you don't have one, officers will put you in jail.
Yes,
Do
sir.
you understand?
Yes, sir. Your Honor, can I speak?
Don't.
No, good. I got.
Don't. I don't want you to say a thing. Now's not the time. You have the right to remain silent, exercise that right. Just don't say anything. Don't. Do you have the ability to hire a lawyer, Mr. Martinez?
Not a phone.
Deputy Miranda's going to give you an application. We'll take a look to see whether you qualify. I need to know everything about you, where you work, how much money you're making, how much money you have at the bank, what kind of car you drive, how many cars, stocks, bonds, mutual funds, everything. And then I'll take a look to see whether you qualify.
Judge, we have that the license is not eligible.
You are not allowed to drive. You will be signing an affidavit with me today, Mr. Martinez, and I'm telling you now, I don't give a rat's behind what your excuses. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. This affidavit is what you're going to be signing, promising me you're not going to drive. Nothing in this world can justify you getting into a car and driving. Jesus comes down and needs to ride to church. Do not drive. You understand me?
Yes, sir.
Mr. Castillo,
Because you don't have a license, because you're not going to drive, I'm going to give you a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming.
That's what I was gonna talk to you about. I was talking to you about my bond conditions.
Mr. Martinez, in the last 1.5 years, you have had 1, 2, 3, 4, 5. You are on your 6th case within the last 1.5 years. There's nothing at this time that you can try to negotiate with me. Do you understand?
I understand, but it's about work.
Stop. All I want is my streets to be safe.
Yes,
And
sir.
if I find that you're in danger, anything one iota, it's just not going to go well for you.
Understand.
Okay, do you mind giving an application and we'll have you swear to us?
Are you with Thomas?
Yeah, I can.
Oh, yeah, we never got Thomas's.
Gary and Thomas?
Yeah, I'll meet them.
Raise your hand.
Ready?
Yes, sir.
Mr. Gallegos.
Daniel Martina Pedraza.
And bless him.
Good morning, Your Honor.
Page 9?
Yes, Judge.
Okay.
Morning, Judge. Well,
Hey, how are you?
it's very good.
Happy Friday, man.
Hi.
Did you say Marquina?
Martina Pedraza.
You, hey, this is now not the time for you to talk to him about this. You are Marquina Pedraza.
Yes.
You're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 18th, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle stalled in a moving lane of traffic. The law enforcement officer approached the vehicle and found the defendant in the driver's seat asleep with the vehicle running and foot on the brake pedal. The law enforcement officer woke the defendant up and
A 0.15 BSC, almost double the legal limit in Texas, and he was asleep behind the wheel with his foot on the brake. If that car had rolled forward, it could have ended in tragedy. The judge doesn't hold back, even warning about immigration consequences. Should harsher penalties be mandatory in DWI cases like this?
noticed a mild odor of alcoholic beverage, slurred speech, and glossy eyes. The defendant admitted to consuming alcohol. Standard field sobriety tests were conducted. A 6 out of 6 on the HGN was recorded. A 7 out of 8 on the walk and turn. A 3 out of 4 on the one-leg stand. The defendant consented to breath and blew a .157 and a .154.
Can you look at the eyes and licenses?
Yes, Your Honor.
So we, Marquina, want to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using any alcohol or illegal drugs, I will put you in jail. No more PR bonds. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you because they sweep it hourly, if they find you, they will put a detainer on you and you will be stuck like Chuck in there until this case is over with and then you get shipped off to immigration. Do you understand?
Yes.
Yes, sir.
If you do not have a Texas driver license and liability insurance, you are not allowed to drive, and that is also a bond condition.
Your Honor, we have no prior DWIs, but the driver's license data is not populating at all. There's no indication.
No license.
No license, Judge.
Do not drive, Mr. Marquina. You will be signing an affidavit with me today promising you're not going to drive. I don't care what your excuse is. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine. Nothing in this life can you say that will justify driving. Do you understand?
Yes, sir.
Temptation is big. Just don't do it.
Okay.
So for now, I'm going to have you come up here, swear to us that you're not going to drive. We will get you to Victoria where you will sign a reset. You will eventually get with pre-chopper your bond conditions, and after that, you'll be free to go. Because you have a lawyer, I'm going to waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with counsel, and he will tell you if and when you have to come back to court. If he tells me that he cannot get a hold of you because you're ducking and dodging phone calls, text messages, I'm going to issue a warrant for your arrest. If they call you to go take a drug test and you fail to appear, a warrant for your arrest will be issued.
Yes, sir.
All right? Come on.
Thank you, Judge.
Thanks.